If you've just been arrested for domestic violence, I know how overwhelming this feels. You are terrified of jail, terrified of having a conviction on your record, and right now you are just scrambling for answers and hope. You might have heard, maybe from an internet search, maybe even from another video that I've posted, that in domestic violence cases, to avoid a conviction, it is sometimes possible to do classes in exchange for a dismissal. Let me tell you an important caveat. In California, there is no official diversion, and diversion is completing conditions like classes in exchange for dismissal for domestic violence cases. The law specifically excludes domestic violence cases, but sometimes, depending on the DA and the judge, you can get what is nicknamed informal diversion, where if you complete classes, the case will be dismissed. The problem is that this option gets denied in domestic violence cases all the time. And in this video, I will be explaining the number one reason why diversion gets denied, because if you understand it, and if you take the right steps, which I will also explain in this video, you can avoid the trap that leaves so many people stuck with a conviction that can never be removed from their record. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. The number one reason diversion gets denied in domestic violence cases so that you can avoid it and you can get your case dismissed in exchange for classes. So first, I know I touched on it, but let me explain a little more. What is diversion? Diversion generally means that in a criminal case, if you complete certain conditions, then the case will be dismissed. Now, in most criminal cases, you get this either by the prosecution agreeing to it, or if they won't, by the judge granting it. Either way, it does have to be approved by the judge. Now, examples of where this applies, where you can get diversion, where there is actually a law, a statute that says that you are eligible for diversion, is if you are accused of theft. You might have to do anti-theft classes in exchange for a dismissal. You get into a bar fight, you're charged with battery, maybe you do some anger management. All of that is allowed for by California law. That is called diversion. But for domestic violence cases, that same law that gives diversion to people accused of theft and battery does not apply. It is specifically excluded. The law specifically says domestic violence cases are not eligible for that. However, prosecutors and defense attorneys have found sort of a workaround to this, where they keep the case open and agree that if you follow certain conditions, usually domestic violence classes at minimum, then the case will be dismissed. That way you avoid a conviction. But here's the catch with this informal diversion. While you're doing those classes, the case has to stay open. And judges generally do not allow domestic violence cases to stay open for much longer than a year. Now, usually prosecutors want 52 weekly sessions of classes, a year of classes. So if you haven't started the classes early, if you are asking for diversion, maybe 6 or 8 months down the line, so you have your first court date, you have court dates maybe every month or two, 6 or 8 months, your attorney proposes to the prosecutor this informal diversion. Even if they say yes, in most cases, the judge is going to say no, it's too late. They're not going to be willing to keep the case open. Now, the reason for this is not that the judge is lazy or that the judge is being mean. The thing is that judges have a duty to get cases off their dockets. If they allow their dockets, the number of cases that are heard in that courtroom, the number of cases that are on their calendar every single day, if they allow that to get too long, then they are not going to be able to deal with those cases appropriately. So part of their job, part of the metrics by which they are evaluated, depending on the county, is are they keeping those cases closed? If they have cases that are open for longer than generally a year, there are going to be questions. And unlike in theft cases or battery cases or similar misdemeanors that are eligible for diversion, they don't have that diversion statute to use as a shield to explain why the case is open. Now, when the judge says, 6 or 8 months down the line, even though the prosecutor agrees to informal diversion, when the judge says no, that would keep the case open for way too long. At that point, the prosecutor is just going to say to your attorney,
well, your client should have been doing the classes all along. There's nothing I can do about it.
And that's it. Diversion denied. Now your only choices are generally going to be a conviction, usually with probation that makes you take 52 weeks of the domestic violence classes anyway, or going to trial. So not taking those classes early, not having a bunch of them done. So you can say, my client has already taken half the classes that they need. We only need a few more months. That's the number one reason why diversion deals fall apart. And one of the reasons I'm making this video is that this is where a lot of lawyers let their clients down. They do not guide them to start classes early. I hear from people in this situation all the time. Their case has been open for 6 months or longer. They call my office because they don't like what's happening with their case. One of the questions that we ask them is, are you doing any classes? Are you enrolled in therapy? Have you done any anger management? Basically, what have you done so far? And most of the time, the answer is that their attorney never told them to do that. Now, why not? Because it is genuinely, it's uncomfortable. Clients do not want to hear that. A lot of lawyers don't want to upset their clients right after they have just hired them. So they say nothing. They keep the client comfortable in the short term. They don't tell them to do these things that, yes, take time, cost money, are annoying to do. And then months later, when diversion gets denied, the attorney blames the DA or the judge. But that does not protect you. You are still stuck in this situation where you may end up with a conviction that probably could have been avoided if you had the right information and you knew to start early. And I don't think that that's the right way to approach things. You hire a lawyer to always be straight with you, even if it's not what you expected to hear, even if it makes you uncomfortable. Because to me, my job is not just to keep you calm and happy in the moment, just kick the can down the road of the bad news later and try to blame somebody else. My job is to do everything that I can to protect your record, your career, and your future. So at my law firm, we guide clients to start classes and other proactive steps depending on your situation right away. And I know that it feels like, and I've heard the pushback sometimes, one more burden on top of everything else that you are dealing with. But I also know that it is the key to keeping that option of this dismissal in exchange for classes on the table. And there are affordable ways to get started. Many programs are on a sliding scale, and we can help you find the ones that fit. And on another note, this isn't to say that you cannot win at trial or that we are giving in or that you should take a plea deal. I always explain to my clients, look, my job is to get you options on the table. I want to get you the best possible option that I have on the table. If I get you, 52 weeks of classes, you've already done half of them, you do 6 more months of them and the case gets dismissed and you tell me, no, I want to go to trial, then I'll talk to you about what I think your chances are at trial. It doesn't mean that your case is unwinnable, but it means that you deserve to have that option on the table. If you decide not to take it, that is up to you, but it's my job to get you the best possible options and not say to you, as I know a lot of attorneys say, well, you didn't want a deal, so that's why I didn't tell you to take these classes. Because if you do take it to trial, the reality of 12 random people deciding your fate, and if they don't decide in your favor, having a conviction, having the judge sentence you to up to whatever the maximum is for your case. If it's felony domestic violence, generally 4 years in state prison. If it's misdemeanor, up to a year in jail. Sometimes at that point, you might start thinking, okay, well, what are my other options? You should have those options and the best options that we could possibly get on the table for you. Now, I've guided many people in your exact position, people who were scared, who were overwhelmed, and who were convinced that their life was about to unravel. And they did walk away without a conviction. That is what I want for all of my clients. Last year, 95.83% of my clients avoided a conviction. So every case is different. That is not a guarantee, but that is my goal, to avoid convictions. And so here's the bottom line. The number one reason why this diversion gets denied in domestic violence cases is because the client did not start early enough. If you're watching this video and your lawyer has not told you that, talk to your lawyer about that, because it may have slipped their mind. They may do all sorts of criminal defense and not really be focused on how domestic violence cases are different and how you do need to be proactive. Or they may be avoiding a hard conversation, and then you'll be the one to pay the price later. I hope you found this video helpful. If you are facing a domestic violence charge and you want an attorney who will be honest with you, who will guide you step by step, and who will do everything possible to keep you from ending up with a conviction, call my office. You can book with us directly via the Calendly link down below. You can also find our number there. And if you did find this video helpful, please don't forget to like, subscribe, and ring the bell.